Welcome once again to What's Going On. My name is Dolores Vidal, and Janette Cranshaw and I are very pleased to welcome John R. Hope, attorney at law with a practice in Watertown, Massachusetts, serving our community as well, who is here today to discuss what I think is of great interest certainly to me, and to a vast number of us in town who are somewhat older than we used to be, and perhaps making some preparations for how to look after ourselves and how to look after those who remain once we are gone on a little trip. So, without further ado, I'd like to introduce John Hope.
Thank you, Dolores. It's a pleasure to be here. I have my practice in Watertown over by the Arsenal Complex. Mm-hmm. I've been living in the area ever since I attended Boston College Law School. And when I went to law school, I had in mind that someday I would work in an area of law where I got to work directly with people, helping them solve problems. Now, I didn't know at the time what area of law I would be in, but several of my classmates from law school entered the field of elder law and estate planning, and after speaking with them and seeing what their practice was, I felt that this was a good fit for me because I like to help people do advanced planning, and I also like to help them solve problems that may arise in their lives. And I've also been told that my personality is one where I make people feel comfortable when I'm working with them, helping them solve issues that they may have.
Well, I think that's a very good start, because if I were to use myself as an example, I would say that I wouldn't be surprised if people are intimidated by even beginning to approach the problem. It's so overwhelming in its breadth that to have somebody to whom one can speak and begin to order in one's mind what needs to be done would be very useful. I wonder if you would tell us, please, how do we go about doing that?
Well, it usually starts with a phone call to my office, during which I will spend some time personally on the phone with someone who's calling to inquire about their particular issues. I'll find out from them whether I'm the correct person for them to be working with. Sometimes I make referrals to other attorneys or other service providers. Once we've determined that I'm the correct person to be working with, I send out a questionnaire ahead of time that will be filled out prior to the initial appointment. And at the initial appointment, we talk about the issues of concern to elders, and some of those issues typically are making sure that they have some of the basic documents in place to appoint others to be able to help them if they become incapacitated or weakened and need help making decisions. So I would say that the place to start is by making sure that you have the appropriate, what we call competence planning documents in place, which would be a power of attorney, healthcare proxy, an advance directive, and a HIPAA authorization and release. Would you like to hear a little bit about those?
I would.
The fourth one was called HIPAA, and HIPAA sounds like hippopotamus, but it's not. It's spelled, it's all capitals. It's spelled HIPAA. And what many people have heard that word because it's the Health Insurance Portability and Accountability Act. It was originally signed into law in 1996, so when people changed jobs, they would get to have the next employer's insurance cover pre-existing conditions. As part of that, in 2003, the federal privacy regulations were implemented. What that means is that doctors and hospitals, any healthcare providers, cannot release your personally identifiable healthcare information to anyone unless they have written authorization to do so. So one thing that could happen is if you have a child, an adult child, who's concerned about their parent and they want to call the parent's doctor to make an appointment to bring the elder in, and gee, mom's seems a little bit out of it today, and I'm concerned, I'd like to bring her in. The doctor's office may say, well, your mother is our patient. She needs to call to make that appointment. So what this HIPAA authorization document does is it lists the people who have authority to sign a medical release at the doctor's office or at the hospital, anywhere, to be able to have access to the elder's medical information. So essentially what it does is it removes artificial roadblocks to access to medical information. Now, prior to 2003, this wasn't required. Doctors and hospitals would use their common sense, and if it was the adult child of the parent asking, to make an appointment or to get some information, they would use their common sense and give them that information. The first document that we talked about, or that I mentioned, was called a durable power of attorney, and that's a document in which the elder, or a younger person as well, would appoint one or more people to be able to assist them with financial matters in the event that the elder becomes in some way incapacitated or unable to handle matters themselves. If the elder has trusted children, these would be, depending on the health of the spouse, you might appoint the spouse, or you may appoint one or more children. Only one person at a time can act, and then you would name.
But you can have alternatives?
Yes, alternates.
Alternates.
This has been said to be the most important document to have, and the reason for that is that if you don't have the ability to deal, if you haven't appointed someone to be able to deal with your assets, specifically with any assets that you may own individually in your own name, then you're going to have to take an expensive trip down to the probate court to get legal authority from the court. It's called a conservatorship. And the state legislature specifically has authorized powers of attorney because it's much more efficient for someone, while they're of sound mind, to be able to sign a relatively inexpensive document naming who they would like to be able to assist them at some future point when they need help. Now, in the context of elders, we often like to make sure that we have the ability to transfer assets out of the elder's name, and we'll be talking about a little bit more later about why that's so important in terms of asset protection.
Let me interrupt you just for a second. I want to back up a little bit and ask you, what happens if the elder hasn't reached the point of making this phone call, but a child, his child, is noticing that there's some failing in their parent?
Well, I often get phone calls from adult children. Now, I can't, I always represent the elder. So if the child calls me and says, I'm concerned about my parent, I say, well, that's good that you called. Would you like to set up an appointment to meet with your parent? And you can come too if you'd like, but the elder is always my client.
I see.
So I can't prepare documents for a child to have the elder sign. I have to meet with the elder first and make sure that it's appropriate for them and that this is what they want to do.
And if you determine at that interview that the elder is sufficiently incapacitated in your judgment, what can you suggest?
Well, that would be the case where we would possibly need to go to the probate court to get authority for the adult children
I see.
or one or more adult child to be able to assist the elder. And, excuse me, when you need court authority for health decisions, that's called a guardianship. When you need court authority for financial matters, that's called a conservatorship. As a note, as of July 1st, 2009, they implemented some new rules and regulations concerning guardianships and conservatorships when they enacted the Massachusetts sections of the Massachusetts Uniform Probate Code. And it used to be that if you needed control through the court, authority through the court for both health and financial matters, you could become a guardian of the person and of the estate. So some of you out there may have an existing order that gives you, that's called a guardianship, that gives you authority over both health and financial matters for an elder. Since July 1st, 2009, they've bifurcated or split that. So now a guardianship only applies to healthcare matters, and a conservatorship, as it always has, only applies to financial matters. So if you have an order that was issued before July 1st, 2009, it's fine. You don't have to rush into court to redo it or anything. But for any new matters that are being brought now, guardianship is for health, conservatorship is for financial matters. But again, it's a lot cheaper to do a power of attorney and a healthcare proxy, and I'm about to tell you about the healthcare proxy for medical decision making. It's much more efficient to do those documents ahead of time than it is to wait until you actually need help with your finances or health, because as I said, then you're going to be spending multiple thousands of dollars to go down to the probate court. And with the budgetary cutbacks in Massachusetts, that has resulted in less funding for the state court system, which means that particularly in the county we live in Middlesex, they just don't have the resources that they need at the probate court to get things done in a hurry. So it takes longer now to get things done, and it can also be more expensive because attorneys have to sit around and wait longer down at the courthouse to get things done because it's more crowded. They've got less judges hearing the matters, and so it's these budgetary cutbacks on the court system do have an impact on all of us.
The plot thickens.
I think I wanted to mention the healthcare proxy document. Now, many of you are already familiar with that. You may have already filled out such a form at a doctor's office or at the hospital. The state has a 1 or 2 page standardized form that you can get, as I said, at a doctor's office or a hospital, in which you appoint one person and then 1 or more alternates to be able to make medical decisions for you in the event that your treating physician determines that you either temporarily or permanently are unable to make or communicate informed healthcare decisions. So when you sign one of these documents, it doesn't automatically right away give authority to someone to make your medical decisions for you. It's only if your doctor, your treating physician, determines that you need help. Now, I'd like to point out...
It's a healthcare proxy.
Healthcare proxy, yes.
Somebody should...
And there is some additional language that it's permissible to put in the healthcare proxy document that is not in the state form, and it pertains to the use of a certain class of medications which may be indicated for someone that has advanced dementia or advanced Alzheimer's, and those medications are called antipsychotic medications. For younger people, they're used to treat mental illness, but as I said, for elders with this advanced dementia, they can be indicated to help calm the person down so that they don't become highly agitated and hurt themselves or another. Now, if those medications are needed and the medical decisions are being made pursuant to the healthcare proxy by the healthcare agent named in it, some facilities will say that's fine. You have a healthcare proxy in place. You can consent to the use of the antipsychotic medications. However, some facilities will insist that if that language does not appear specifically in the healthcare proxy, that you go to court and get a guardianship with authority for the medications, and that can be, again, an expensive proposition. So sometimes when people come to see me, they say, "Oh, I've already got a healthcare proxy. I don't need an improvement to that." But there's the opportunity to provide a better document. And then the only one of the documents of these 4 competence documents that we haven't talked about is an advance directive or a living will, and that is an expression of one's preferences for end-of-life medical care, specifically relating to the use of intubations and other types of life support machinery. And in Massachusetts, that's not a legally binding document. If your healthcare agent is making decisions for you, then you're going to it's going to be up to the healthcare agent to make those end-of-life treatment decisions. But this is a document that your healthcare agent could show to a treating physician if it becomes time to make a difficult decision. Some people like to have a document like that. Other people don't. There's a story about a woman who had tattooed on her chest, "Try CPR one more time." So the different people have different views on that.
I was going to say that I have something that is like that, the Rogers monitor for my blind and handicapped brother, so that I can be in on, the state has to come to me, do I approve of all these medications, and am I aware of it? It's very interesting because...
Well, you know, this might be news to you, but it used to be that the Rogers, now a Rogers monitor is something that's put in place by the probate court.
Right.
And it used to be that the Rogers monitor was the person that would make the decisions about whether it was okay or not to use the particular medications. But effective July 1st, 2009, it's now the court, the judge, that has to approve the medical treatment plan. And the Rogers guardian or the Rogers monitor is the person who's making sure that the medications are working okay, and you know, they're the lookout, the eyes and ears, to make sure that everything is working and the person is getting the appropriate care. But it's no longer the Rogers monitor who authorizes the treatment plan. It's now the court that authorizes the treatment plan. These changes in the guardianship and conservatorship rules came about because of partly because of an investigatory series that was done by the Boston Globe, showing that there were cases where people were put under guardianship and then sent off to nursing homes and things that the people didn't really need to be under guardianship. And so what they've done now is they've included more protections in that process. Now, one of my challenges here today is that I sometimes speak in very great detail about individual subjects, and I know that what you really want is to get through a sort of an overview of various topics of interest to people, so I'll try to be a little more brief.
Okay, and before you continue, I would just like to say that if you have interest in contacting John R. Hope, Esquire, he can be found at 200 Dexter Avenue, Suite J in Watertown, or you can reach him by phone at 617-926-8549. And he has a website, which is www.hopelawcenter, all one word, .com.
Thank you.
So you were going to say, before I rudely interrupted.
That's okay. I've actually, a couple years ago, began doing business under the name Hope Elder Law, to reflect that that's the focus of my practice. So it's some of the, you can get to my website at hopeelderlaw.com or at hopelawcenter.com.
Okay.
I was noticing that you handle legal matters to do with such a variety of things. I'd just like to run down it a little bit so that people would be aware of what might get covered. Some of it's been coming in and out already in your discussion. Estate planning, wills, trusts, estates, incapacity planning, healthcare proxies, durable powers of attorney, elder law, public benefits that are available, Alzheimer's disease, I presume that would be specific things that would have to do with that, Medicare, Medicare planning and applications and hearings, nursing home care, in-home care, guardianships, conservatorships, which you already discussed, probate of wills and estates, inheritance disputes. Oh, that sounds lovely. I want the car. Yeah. Disability planning, special needs trusts, that's what I've been involved in, and Social Security disability. So that's a lot of stuff that you know all about, and that you have obviously found that comes back and forth when you're dealing with somebody. About probably 6 of these things come into play in any one client.
And you might be wondering what the term elder law means. Elder law was a term that was coined about 20 years ago to mean a focus on the areas of law that affect both elders and persons with disabilities around planning for access to health care, planning for, as you said, the succession of property when you pass away, and with persons with disabilities, again, around health care, accessing public benefits for health care, protecting assets. I don't deal, for instance, elders may own real estate, and I sometimes facilitate the transfer of real estate into special trusts to protect real estate, but I have a real estate attorney draw up the deed because the real estate is a specialized area of law. So sometimes I use other experts to help bring together the plan of action that I'm implementing.
Is that, in the case of real estate, does that need to have been done prior to 2 years or something from the death of the owner in order to avoid probate? Or do I have it all wrong?
Well, you're asking the type of question that I often hear from people because there's a lot of terminology out there and they're not really sure what it all means. I guess I'm going to talk a little bit about probate and about planning how your assets can go on to the next generation. And then as part of that, I'm going to tell you a little bit about how you can make sure that those assets actually get to where you want them to go. Because nowadays, if you need long-term care, either in home or in a nursing home, that can be very expensive. There are public benefits that are available to assist with paying for those. However, advanced planning may be required to protect your assets for your family. Now, probate is the administrative process at the probate court whereby assets that someone owns individually in their own name when they pass away that do not already have some other way to change hands designated, they have to go through the probate process so that the title, the ownership of it, can be changed. So certain types of assets are not probate assets. Joint accounts or jointly owned real estate are not probate property because under the rules of joint property, they pass to the survivor. If you have a financial account that has a beneficiary designation on it, that will pass to the beneficiary. It doesn't have to go through probate. So again, and a will is a set of instructions to the probate court on how to disperse your probate property. So some
I
people
see.
think because they have a will that that's
I
going to
see.
determine where all their property goes, but their will only distributes their probate property.
I see. I see.
Now, if you want to avoid the probate process, one way to do that is to have your property held in a trust. A trust is an arrangement where the person who starts out owning the property, called the donor, transfers it to another person called the trustee, and the trustee manages it for the benefit of the beneficiary. So trusts can be used to avoid probate, and they can also be used to protect assets. Now, in the event that you want to, say, protect a home, you have to do that 5 years ahead of time.
5 years.
Now, it used to be you could do certain things 3 years ahead of time, but if you end up in the nursing home and you want to apply for Medicaid, which is called Mass Health here in Massachusetts, to pay for your nursing home care, you need to have done any property transfers at least 5 years before that. So we try to get that word out to people because, especially in this area, real estate is very expensive, and people might wish to protect a home for the benefit of their children rather than having it be used to pay for their nursing home care.
Needless to say, you have oodles to say, and twice as much for us to hear than we have time for, unfortunately. But it has been such a pleasure having you here today. So I think Janette and I would like to say we need to invite this gentleman back again
Definitely.
in the future.
Definitely.
Thanks. I'd be delighted to come back, and then
Yeah.
maybe we can spend more time on specific
Yes.
topics.
Yes, and if any of you out there want to make any comments regarding the subject of today's show and have questions to ask, number one, I think you can let us know of your great interest. And secondly, you can contact Mr. Hope at the number or address that we gave you.
This also, as part of Elder Law Month in May, I'll be giving a presentation at Springwell, which is
great.
the local aging services access point that's on Walnut Street in Watertown. And I think that's around May 14th, so you could contact Springwell directly if you'd like to get the date on that.
Excellent. Thank you very much.
Thanks for having me.